Hello, everybody. This is Breaking-ish, and today we're going to do a review of the last January 6th committee hearing. If you are new to the channel, please like and subscribe. And as a housekeeping matter, a couple of housekeeping matters, you may see my puppy dog get up and try to get my attention. He's currently napping, but you never know with him. And the second is I've tried very hard, but I can't get rid of my B. Arthur hair. So, yeah, that's where we are. So, on to the substance. The January 6th committee hearing was satisfactory. They did what I would have expected them to do. But in my opinion, it was conservative. So I'm going to do an unscripted review of, scripted as in I had this, a note card, and would like to do an unscripted review of the hearing and then the criminal referrals. I obviously am somewhat disappointed that the committee did not make criminal referral for a seditious conspiracy. But I still maintain that the committee did present information that is ample to support a charge of seditious conspiracy. And I will explain a little later why I believe the committee didn't make the formal referral for seditious conspiracy, but did for incitement of insurrection and 2 statutes of fraud and what was the other one? I don't recall exactly. So it was 4 charges, and conspiracy to defraud, insurrection. I think there were 3 conspiracy charges. Anyway, but the committee left a lot out. The committee left out, as I said, the charge of seditious conspiracy, for which I believe there's ample information that the committee provided. It did not go at all into the lapses of law enforcement on January 6th and before. At the final hearing, they did touch up on it at the 9th hearing with what information they received about Secret Service. We also know that Secret Service destroyed messages from that day that are still not retrieved. They're not retrievable. So, and we learned about the tussle with Tony Ornato and Bobby Engel and that information from Cassidy Hutchinson. So they did touch on it, but they did not get to referrals for law enforcement agencies. And I believe the reason is the same as why they didn't make criminal referrals for seditious conspiracy. They did not talk about much about the witness intimidation and tampering, but for it saying that there are instances of it, and they didn't raise that as formal referrals. But even at the last hearing, they mentioned about lawyers not disclosing to people who were being intimidated or tampered with where the money was coming from that paid the lawyers. So, but they didn't in the investigation or in their hearing. Or we'll learn more from the report when it comes out, whether they will discuss these issues or not. And I would assume that they would, because they couldn't pack all of the information that they revealed to us in 9 hearings in an hour, like that the last hearing was. I believe the last hearing was mostly to summarize and then make the referrals. And here's why I believe that the 4 charges for which the committee made the formal referrals are conservative, and that there's still information from what they have gathered that the DOJ can use to pursue charges of seditious conspiracy and charges against members of law enforcement and then follow the money and address the issues of witness intimidation. I believe that the charges for which the committee made the formal criminal referrals are charges for which the committee has information that they believe would pass the evidentiary muster, that would be admissible in a court of law and not be considered hearsay, or not admissible in court because of prejudicial, that they're highly prejudicial for somebody. Now, or to Donald, and the probative value, the evidentiary value is low compared to the prejudicial impact of that information. So I believe that the four charges for which they filed the formal criminal referrals were charges for which they have presented information and they will present information in their report that passes evidentiary standards, that would comply with federal rules of evidence and would be readily admissible in a court of law, meaning those charges are ripe to be taken, and the DOJ can file indictments on it if they've already been doing their investigations. But according to the committee, these four charges, they have information that rises to the level of evidence admissible in a court of law, to a fact-finding jury, which is critical in enforcing the rule of law, is following due process of law. Now, with seditious conspiracy, and with seditious conspiracy specifically, because that's the charge that I am honed in on, I believe that there is ample information that the committee has provided that can open doors for Jack Smith and his federal prosecutors and investigators to go out and seek evidence through grand jury subpoena and through voluntary testimony of people that would comply with federal rules of evidence and not be hearsay. And one specific example of that is what we heard from Hope Hicks, and then her text message, and then what the conversation that she had with Eric Hirschman, and then about what Hirschman told Donald Trump. All of that information, mostly at Hope Hicks's information, which is what we have under oath at this, that we see, is hearsay, because it is, she said, he said to him. It's not Eric Hirschman testifying in court that this is what he told Donald and this was Donald's reply. And that would, even that would rise to the level of, that would, I mean, I'm not very good with federal rules of evidence. I mean, I got to be in that class, and I've not been in court in over a decade. But, whether what Hirschman says under oath or at trial and deposition as to his conversation with Donald Trump may be have evidentiary value and fall within the rules of evidence. But my point is that DOJ now has to parse through all of this information, all of these sources that to the layperson, to the American people, it's truth. It is Hope Hicks testifying under oath, under penalty of perjury, to Congress that this happened. I had this conversation with Hirschman, and Hirschman told me this, that he had this conversation with Donald Trump. But in a court of law, that is hearsay. That is he said, she said. It has to be proved that falls outside, that it's not hearsay and therefore can be admissible. And for that, the DOJ has to pursue Eric Hirschman's testimony, has to investigate if there are other people with whom Donald Trump had a similar conversation, and then corroborate one through the other, to the other, because you're never going to get Donald Trump to come to the stand and say, yes, I had this conversation. So, and that's what makes proving the charge of seditious conspiracy so difficult in the case of Donald Trump, because there has to be direct evidence of it. And at some point, if we find in a text message or something that the DOJ has uncovered, or a phone call, or something from Mark Meadows' text messages and John Eastman's emails that rises to the level of direct evidence, then the DOJ, I bet my bottom dollar, will pursue the charge of seditious conspiracy. But I want you to be aware that the Secret Service deleted messages from that day. God knows how much evidence Donald Trump has destroyed and flushed down the toilet. And that's not even a joke. He actually did that. There are pictures of that. And the fact that he has been given 2 years to cover his tracks, he may not be able to, but that burden lies with the FBI and the DOJ, not with the January 6th committee with their limited budget and limited time. And at every step that this investigative process has gone on, both with the DOJ and with the January 6th committee, Donald Trump has thrown up obstruction after obstruction after obstruction. He hasn't really said, yes, I'm going to comply with the rule of law. He has said, I have a reckless disregard for the rule of law. So I'm going to do everything to the point of being sanctioned for frivolous lawsuits to get in the way of the DOJ investigating me and pursuing me and delivering justice to me. That's clear. But the committee has been conservative in not addressing the issues over which they have information, but not evidence that rises to the level of complying with federal rules of evidence. But mind you, this information will lead to evidence that the FBI and the DOJ now have the leads to, because of the January 6th committee's work, to pursue. It's much easier now for the DOJ and Jack Smith to pursue these people because the leads are provided, because many people have testified under oath that they spoke to these other people. So if Hope Hicks is lying, today Hope Hicks would be liable for penalty under perjury. So now it's up to the DOJ to rely on that information and go to Eric Hirschman and to any other people who they find to have the similar conversations with Donald Trump about what was going on. And this distinction, I believe, is the reason why the committee has been conservative about it. And this limited scope through which the final report will come out through, I believe, will help the committee's work not be seen as political. Because if they call it political, both the committee experts and the DOJ can point to say that the charges for which the committee made these referrals can be proven in a court of law based on the information that the committee has gathered, because that information rises to the level of being evidence that could be admitted into a court of law. They have been conservative and step back from going more into topics that fall completely peripheral to the central idea of what happened on January 6th and who was responsible for it. That's the core mission of this committee. And they complied with that core mission here. So that's what I have to say about the committee's hearing. And one more thing that I want to discuss is after the committee after the committee made criminal referral for rebellion insurrection under 18 U.S.C. 2383, the conversation has now come up about disqualification from office. As it stands, and this is coming from somebody who hasn't really studied the Bill of Attainder, but it is simply put the understanding that you cannot really deprive somebody of life, liberty, or property without due process of law. And trial by legislature or any sort of punishment imposed without due process of law or as prescribed under the Constitution, under the impeachment clause, would be violative of the Bill of Attainder of this idea that taking some life, liberty, and the right to property away from an American or somebody appealing to an American court is violative of basic due process of law. And we have right to trial by jury. We have right to due process of law based on the Bill of Rights. So short of being indicted, prosecuted, and convicted of incitement under 18 U.S.C. 2383, the process for disqualification of Donald Trump from taking political office was the impeachment process. And despite the fact that 7 Republicans voted to convict Donald Trump at the trial, the impeachment trial in the Senate, it wasn't 2/3 vote that was needed. And on that, the GOP failed us because there was ample evidence there. Now, the only process that wouldn't violate our due process and thereby this thing called the Bill of Attainder is going through the trial process, going through the evidentiary process, going through the fact-finding process to see that Donald Trump did incite an insurrection and therefore he's disqualified from office. And there's been talk about what would be the enforcement mechanism of being charged and then convicted of 2383. It is a law that is written, and it says the punishment for this law is, I think, 5 years in prison and disqualification. Shall be disqualified. It's not sort of a discretion of the court at sentencing to say, no, okay, we're not going to include the disqualification aspect of it in my order. So whatever the actual prison sentence would be for the conviction of insurrection, the disqualification part of the punishment that's statutorily mandated would attach automatically to a court order of conviction at sentencing. So when, upon sentencing, when the judge signs that order, obviously he's going to appeal it, and I'm just sort of looking forward, and he's going to appeal, it's going to go to the Supreme Court. Whatever that happens, the facts remain, therefore the fact-finding will remain, therefore the conviction will remain, and when the conviction remains, the sentencing guidelines, unless there's an abuse of discretion for the sentencing, which in the case of a mandatory stipulation in the statute, that disqualification is a requirement. They shall be disqualified, not may or can. The Supreme Court will abide by the statute, and therefore the disqualification will stick. And the enforcement of the disqualification will be if Donald Trump ever files for running for office, federal office, anywhere, then it would befall on the government to sue in the court in that jurisdiction and say, no, he cannot file for elected office because under this order by court, because of his conviction as a mandate, a statutorily mandated requirement of his conviction for insurrection, he cannot even file because he's disqualified from elected office. So the enforcement step of it would be when the order is issued, after it has been adjudicated and the appellate process has been exhausted on the charge of 18 U.S.C. 2383, that the DOJ will send out this order to every single Secretary of State in the country. And that will be on their record, and it will be on public notice as required by law. I think there's a period of time that you have to put it out in newspapers across the country. And it would become a matter of public knowledge, and it would be pinned on the boards of DOJs and courthouses, federal courthouses, and federal clerk's offices, and Secretary of State's offices all across the country till the end of time, or at least till Donald Trump croaks. So that's how you enforce the disqualification enforce a disqualification requirement and mandate in the statute. And short of that, the only sort of way for him to have been disqualified was through the impeachment process. And the GOP failed us there. Despite having 7 who were courageous, there weren't 8 more who would have come out and said, okay, or not 8, or I think like 10 more. It was a high number. It's a high number. But the number, the evidence is there. And I believe that the committee, by making the criminal referral for 2383, says that the evidence is there. The evidence that would be admitted into a court of law, and evidence that would have been sufficient for the GOP majority Senate to convict if they were looking at the facts, and if they were looking at the truth, and if they were defending the Constitution, which they did not. So at this point, the only way for disqualification is the process that I just explained. So that's pretty much all I have about the 10th. And hey, guess what? E99 DISP. I just figured out what your name means, and I think I had a little moment. It's emergency 911 dispatch. I mean, maybe I'm right, maybe I'm wrong, but it should have been more obvious, I believe. But I wasn't thinking about it. But then I had to think in my head and figure out your name, and so I came up with that. Let me know if I'm right or wrong. And thank you for being here. So with that said, I appreciate all of you being here. If you're here, please like and please subscribe. I rely on your support and your time. I never have, and I never will ask you for money. My theory for making money is to be able to monetize my channels and my reach, so I can get advertising dollars from YouTube. And that's how I would like to be able to make the money that I desperately need. I am destitute. I have a huge student loan on my head, but I'm not going to, it's just not in my mettle to ask for money from people, or to ask for donations, or to even go out and say that read my article for money. It's just not in my DNA. So my goal is to be able to get my word out in large enough numbers, despite me talking about a niche issue of constitutional law and law in society, that I'd be able to reach out to enough people who are vested in the preservation of our republic, for them to at least give me the time and the watch time hours and the algorithmic magic can work to be able to put me up to a point where I can get advertising dollars from YouTube. Because that's how YouTube helps out content creators, is that if you reach a level of watch time hours, if you reach a level of being shared, if you reach a level of having your posts and videos liked, then they reward you for that by giving you a portion of the advertising dollars. And so at this point, this is my only outlet. I have 4 self-published books. If you search my name on Amazon, OEISHIK, Oishik, and those are also for sale for a very trivial $1 or $2 or something like that. And if you do get the first book, which is Audacity to Understand Knowledge, you would tribute to Sam Stewart, Audacity to Understand Knowledge, you would get my philosophy of not asking for money, because I believe that information and truth and getting it out to the people, you cannot put a dollar amount on it. And if I were to put a dollar amount on it, no one would pay it, because it would be an exorbitant amount. Information is either free or priceless. I guess it's free because it's priceless. So, and I believe that people have a right to believe in information that is freely given and truthful, and not tied to any agenda, but for what I can get from YouTube, from the advertising dollars. And if any other platform monetizes, I will try and see if I can make it to that. But short of that, you are, and your time is my only hope. So please, Obi-Wan Kenobi, you are my only hope. Please like, subscribe, and share. And I love you. And yes, 20 years, retired. So I got it right. Haha. Thank you. I love y'all. I'm going to take off now. It's been 25 minutes. I hope this information helps. Thank you so much for sharing. I really appreciate it. You're going to have to share your name with me at some point because I can't keep calling you Edis, Edis, whatever. You get it. So what's your name? If you're comfortable, please at least um, hey, Anthony, thank you so much for being here. I really appreciate it. Thank you, Derek. Thank you, Derek. I'll remember your name, so I don't have to keep calling you E91 this. Well, but I figured it out. Thank you so much. I appreciate it. Take care.